This module is about legal questions in open science. My name is Max Heber. I'm a member of the University of Konstanz Open Science team. This module was produced in collaboration with my colleagues Livia Gertes and Andreas Kirchner. 3 legal aspects are covered in this module. As a first step, we will look at possible obstacles to publishing research data and publications. Afterwards, we will look at some practical recommendations on how to deal with third-party rights and how to deal with images. Finally, the area of licensing will be covered, explaining the differences between commercial and free licenses and introducing the various Creative Commons licenses. First and foremost, however, I would like to raise your awareness of the fact that this module aims at introducing on a very general basis legal fields that are relevant in the context of open science. None of this information is legally binding, and some aspects vary from country to country. Moreover, legal situations may vary from case to case and may be subject to change. In view of all that, we strongly recommend that you consult legal specialists at your home institution to analyze individual legal situations. As a researcher, you enjoy academic freedom, and this includes freedom of publication in particular. This means that you get to decide whether and when to publish your research results, both your text publications and your research data. What academic freedom and freedom of publication do not give you, however, are property rights. Therefore, irrespective of academic freedom, the rights of third parties must be respected when publishing, which raises the question, who actually has rights to your research results, to your texts, to your data? Logically, of course, this is first and foremost you, yourself. As a researcher, you acquire copyrights, for example, when you write a scientific or scholarly text. Whether research data is protected depends on the individual case. A very general differentiation would be to say that data from the humanities, which tend to work textually, are protected far more often than those from natural sciences, which tend to be more number-based. Also, qualitative research data, for example interviews in social sciences, are generally more protected than quantitative research data. The concrete type of research data is crucial here. For more information, please consult legal specialists at your institution. In addition to your rights, third parties can also claim whatever your country defines as copyright positions in your texts and data. This applies in particular if you reuse other people's work in your research, for example, if your text publication includes other people's illustrations or if you use other people's research data in your project. In the case of open access publishing, third-party rights are particularly relevant when you want to make a text publication, which you have already published with a publisher, available via an open access repository. This is referred to as self-archiving. If you want to self-archive, it is important to find out at what point in time you may do so in accordance with your publisher's regulations. Here, Sherpa Romeo is a very good source. Moreover, data protection can mean that rights to your research data go to third persons. This is the case if your text or data publication contains information about other people, which clearly identifies who these people are. In this case, data protection does not give the persons concerned any ownership rights to your research data, but it may very well result in a prohibition on data processing for you as a researcher. Typical examples of personal research data are health data in medical research or survey results in the social sciences. By contrast, data protection law does not apply to information which cannot be attributed to a specific person in the first place. The same goes for data which have been rendered anonymous in such a way that identification is no longer possible. Personal research data may only be processed if the processing can be based on the consent of the person concerned or on legal standard. Consent does not require any special form. However, it must be verifiable, for example in the case of a review by the Data Protection Regulatory Authority. That is why written or electronic documentation is strongly recommended. It should also be noted that, in general, consent may be revoked at any time, pursuant to Article 7, Paragraph 3 GDPR. However, if consent is revoked, this only affects future surveys. The data already collected may continue to be processed. In principle, the data subject can also demand that the collected data be deleted, but there are wide-ranging exceptions for science in particular, which also makes sense, otherwise any study could suddenly run into trouble even after years of publication. In addition, there may be other obstacles to publication. On the one hand, this could be unplanned patenting, because only an invention that is new can be patented. If an invention has already been described in a text publication or by published research data, it is no longer new and thus no longer patentable. If you are planning a patenting, you should wait for its completion before publishing research data and texts. However, confidentiality agreements may also prevent publication. These may arise, for example, from employment contracts or from cooperation agreements with project partners. As what can be regarded as legal ownership of research data is a rather complex issue, we will look at that in greater detail on the next slide. It is important to know that ownership, or the so-called ownership, is an imprecise term at this point, but that the question being addressed is along the same lines as the question about ownership. A large number of people can have access to research data, and they may well do so in parallel and in competition with each other. The researcher may have whatever your country defines as copyrights to data, databases, or software they have created. The prerequisite for this is usually a sufficient level of creation or the existence of a neighboring right. In addition, depending on your country, the researcher may have a patent right and ownership of private computers or servers. This is a contrast between researchers' rights and the copyrights of third parties, especially in the case of subsequent use of third-party data, databases, or software. In addition, cooperation or project partners can be co-authors of the jointly developed research data. Moreover, as previously mentioned, the issue of data protection should always be considered when data contains sensitive information about third parties. Let us now move on to another level. Universities or other research institutions can, under certain conditions, also acquire legal positions in your research data. In particular, the previously mentioned sui generis database right comes into play here. Here, a research institution or university can acquire rights if it has carried out the cost for setting up a database. In addition, in the case of so-called instruction-bound research, copyright may be transferred to the employer. University professors are generally not affected by this. Academic staff, however, may be affected if they have created research data on the instructions of a superior. And of course, universities have property rights to computers and servers used by their staff. In addition, research funders may also have rights to their research data. Here, too, the sui generis database right comes into play. To wrap this up, I would like to give you 4 recommendations for dealing with the rights of third parties. This is relevant for both open access publications and research data management. First, seek advice early so that potential legal problems can be clarified from the very beginning. Points of contact here are the legal department, research data offices, and open access offices of your institution. Second, try to make contractual agreements at an early stage to eliminate conflicts from the very beginning. One example, if qualification work is to be carried out in a research project, it is advisable to make arrangements with these doctoral or master's graduates to ensure that the interests of the overall project are reconciled with those of the doctoral students. These could, for example, provide that a doctoral student continues to have access to the research data for a certain period of time after leaving the project. Third, if it is not possible to make such a contractual agreement in advance, the consent of all parties whose rights are, or at least could be, affected by publications of texts or data must be obtained. These are then in particular the right holders of reused works, project partners or co-authors, and, last but not least, the university itself or the research sponsor if they are entitled to sui generis database rights. Fourth, use standardized licenses when publishing open access or when publishing or archiving research data. Creative Commons licenses are particularly recommended here. This way, the legal framework is clear to anyone who wants to reuse your data. In the following section, we'll be looking more closely at images, as these are frequently subject to third-party interests. I would like to give you 4 recommendations for dealing with images in a legally compliant manner. First, use public domain images wherever possible, for example from sources like Pixabay. In EU countries, intellectual property is protected by copyright law for up to 70 years after the death of the author, or, in the case of works with multiple authors, 70 years after the death of the longest-lived co-author. Second, if you are stuck with public domain, it is recommendable to find images that are under free licenses. Free licenses are not to be confused with public domain. Rather, free licenses means that you must comply with the terms of the respective license. If you use an image under a free license, it is advisable to collect evidence, for example screenshots, that the image was under a free license at one point in time, because if a free license has been granted, it is permanently valid even if the author removes the image from the internet. This way you can prove in case of doubt that you are in the right. We'll be discussing the specifics of free licenses later. Third, a very unfortunate special problem is the reuse of your own images. Commercial publishers in particular often have exclusive rights to their publications transferred to them. If you have done this in an author's contract, this means that, under certain conditions, you also need your publisher's permission to use your own work. A way out of this can be the so-called self-citation. In doing so, however, you must observe the requirements of citation law. Where this is not possible, it may be necessary to obtain the consent of your publisher. Therefore, as far as you can avoid it, I would advise you not to transfer exclusive rights to publishers, but always to grant simple rights, at least according to German law. If at least half a scientific research project was publicly funded and the research results were published in a journal, then the author is allowed to make the accepted manuscript version publicly available, non-commercially, 1 year after publication of the paper, which means that it's ultimately green open access. The condition here is to refer to the initial publication, but if you have done that, you may continue to use images from the self-archived version, if they were research results from this project which was at least 50% publicly funded. Good scientific practice then requires that the citation be acknowledged, but there should no longer be any exclusive rights to the publisher. Fourth, last but not least, data protection must also be taken into account for illustrations. This is always a problem if living persons are identifiable in a photograph. In these cases, you either need the consent of this person, which you should ideally obtain directly when taking the photograph, because later this can often be obtained with considerable effort, or you can find a legal permission that covers this photograph. Now you are informed about some essential picture legal things. In case of doubt, it is recommended to seek legal advice at your institution. If necessary, contact the legal office, the library, open science specialists, or the legal department. The next block of topics in this module deals with licensing. This is relevant in two respects. On the one hand, if you want to reuse other people's data or texts, and on the other hand, if you want to publish your own research results. A license is a contractually agreed right of use. With it, the right holder allows the contractual partner to use the work in various ways. This can be, for example, copying, storing, or making work available digitally. A distinction must be made between commercial and free licenses. First, commercial licenses allow third parties to use the work only against payment of a fee. This is standard practice in the publishing industry. Such licenses protect economic interests, but usually those of the publisher. An alternative model is free licenses. These allow anyone to use the work free of charge. Examples include Creative Commons licenses, Open Data Commons licenses for research data, and the GNU, General Public License for Software, which also exists in various varieties. Such free licenses pursue fundamentally different goals. Here it is not about protecting economic interests, but about opening up subsequent use possibilities on the one hand and maximizing the visibility of your research on the other. At this point, I do not want to make a general assessment along the lines of commercial licenses are bad, free licenses are good. I would rather advise you to consider 3 criteria when choosing a license. The first is you save yourself a lot of trouble and you have a greater degree of legal certainty if you use standardized license texts, which ideally have already been reviewed by a large number of lawyers. This is true for commercial licenses of big publishers as well as for free licenses. Second, I would advise you not to transfer exclusive rights in a license. I explained above why this is problematic using the example of illustrations. Exclusive transfer of rights also excludes you from using your own work. And thirdly, ideally, copyright licenses are compatible with a multitude of national copyright systems because there is no international uniform copyright. For science, which operates and cooperates internationally, this is extremely unfortunate. In my opinion, Creative Commons licenses currently fulfill these 3 criteria best, and I therefore would like to recommend them and to discuss these licenses in more depth here. Creative Commons licenses are standardized usage agreements that make copyrighted content available to the general public free of charge. They are suitable for both text and data publications. For data, however, they have only been fully available since version 4.0, which is why I would strongly recommend them to you. Creative Commons licenses are not only designed to be easy to understand for everyone, but they also offer a high degree of flexibility. This is achieved by the fact that they are composed of 4 combinable license modules. The first license module, the by attribution, requires nothing other than what is common for you anyway, according to good scientific practice, namely that you name the author. Furthermore, as far as technically possible, a hyperlink to the original material and the CC license must be provided. ND and SA deal with the question of whether adaptations of another person's work may be shared. It is important to note that you may edit another person's work. However, you may only share your processing with the consent of the author of the original work. The ND license module denies this consent, which means that you may edit the work, but you may not share your editing. SA allows sharing of adaptations, but only under the same license. It is share alike. The fourth license component, NC, which stands for non-commercial, prohibits commercial use. Choosing the right Creative Commons license thus depends on these questions. A. Do you want to allow for adaptations of your work to be shared? B. Should commercial use of your work be allowed? If the answer to both of these questions is yes, and if you want to allow editing of your work, you will end up with the freest license, CC BY. If you want to allow sharing of adaptations only under the same license, you choose CC BY SA, and if you want to prohibit sharing of adaptations altogether, you choose CC BY ND. If, on the other hand, you want to prevent commercial use of your work, then add an NC to each of these three licenses mentioned, and you have CC BY NC, CC BY NC SA, or CC BY NC ND. Finally, I would like to highlight 4 points about Creative Commons licenses. The first point is, these licenses are equally suitable for text and data. The second point is, there is a lot to be said for opting for CC BY. Not only does this provide maximum visibility, but this license is also increasingly establishing itself as the standard. This has been helped at least by the fact that the scientific organizations such as the German Deutsche Forschungsgemeinschaft and major research funders such as the EU explicitly recommend this license. Thirdly, I would advise against using NC. There are 2 reasons for this. One is that the legal interpretation of what non-commercial means is unclear, and at least German courts have applied interpretations here that differ significantly from the license text. In particular, this means that there is legal uncertainty as to whether privately funded third-party projects at universities do not already constitute commercial use. And the second part is, not every commercial use is necessarily undesirable. And finally, in addition to the Creative Commons licenses just mentioned, there is CC0. CC0 legally represents a waiver of copyright. The problem is, unlike in Anglo-American law, this does not work, for example, in German law. One cannot completely waive one's copyright position under German law. Therefore, this waiver is interpreted as the broadest possible permission of use. Despite this divergence between what CC0 suggests and actually accomplishes under German law, CC0 labeling is recommended in certain cases. This is especially true if it is doubtful whether copyright protection exists at all. Therefore, CC0 is quite common and useful, especially for the publication of metadata and quantitative research data. Here, you can find the sources that were used in this presentation and the list of figures. The only thing left is to thank you very much for listening. I hope you enjoyed this module.